274. Substance of accusation to be stated. When in a summons case the accused appears or is brought before the magistrate, the particulars of the offense of which he is accused shall be stated to him. And he shall be asked whether he pleads guilty or has any defense to make, but it shall not be necessary to frame a formal charge. Provided that if the magistrate considers the accusation as groundless, he shall, after recording reasons in writing, release the accused, and such release shall have the effect of discharge. 275. Conviction on plea of guilty. If the accused pleads guilty, the magistrate shall record the plea as nearly as possible in the words used by the accused and may, in his discretion, convict him thereon. 276. Conviction on plea of guilty in absence of accused in petty cases. 1. Where a summons has been issued under Section 229 and the accused desires to plead guilty to the charge without appearing before the magistrate, he shall transmit to the magistrate, by post or by messenger, a letter containing his plea and also the amount of fine specified in the summons. 2. The magistrate may, in his discretion, convict the accused in his absence, on his plea of guilty, and sentence him to pay the fine specified in the summons. And the amount transmitted by the accused shall be adjusted towards that fine, or where an advocate authorized by the accused in this behalf pleads guilty on behalf of the accused. The magistrate shall record the plea as nearly as possible in the words used by the advocate and may, in his discretion, convict the accused on such plea and sentence him as aforesaid. 277. Procedure when not convicted. 1. If the magistrate does not convict the accused under Section 275 or Section 276, the magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution, and also to hear the accused and take all such evidence as he produces in his defense. 2. The magistrate may, if he thinks fit, on the application of the prosecution or the accused, issue a summons to any witness directing him to attend or to produce any document or other thing. 3. The magistrate may, before summoning any witness on such application, require that the reasonable expenses of the witness incurred in attending for the purposes of the trial be deposited in court. 278. Acquittal or conviction. 1. If the magistrate, upon taking the evidence referred to in Section 277 and such further evidence, if any, as he may, of his own motion, cause to be produced, finds the accused not guilty, he shall record an order of acquittal. 2. Where the magistrate does not proceed in accordance with the provisions of Section 364 or Section 401, he shall, if he finds the accused guilty, pass sentence upon him according to law. 3. A magistrate may, under Section 275 or Section 278, convict the accused of any offense triable under this chapter, which from the facts admitted or proved he appears to have committed. Whatever may be the nature of the complaint or summons, if the magistrate is satisfied that the accused would not be prejudiced thereby. 279. non-appearance or death of complainant. 1. If the summons has been issued on complaint, and on the day appointed for the appearance of the accused, or any day subsequent thereto to which the hearing may be adjourned, the complainant does not appear, the magistrate shall, after giving 30 days time to the complainant to be present, notwithstanding anything herein before contained, acquit the accused. Unless for some reason he thinks it proper to adjourn the hearing of the case to some other day. Provided that where the complainant is represented by an advocate or by the officer conducting the prosecution, or where the magistrate is of opinion that the personal attendance of the complainant is not necessary, the magistrate may dispense with his attendance and proceed with the case. 2. The provisions of subsection 1 shall, so far as may be, apply also to cases where the non-appearance of the complainant is due to his death. 280. Withdrawal of complaint. If a complainant, at any time before a final order is passed in any case under this chapter, satisfies the magistrate that there are sufficient grounds for permitting him to withdraw his complaint against the accused, or if there be more than one accused, against all or any of them, the magistrate may permit him to withdraw the same, and shall thereupon acquit the accused against whom the complaint is so withdrawn. 281. Power to stop proceedings in certain cases. In any summons case instituted otherwise than upon complaint, a magistrate of the first class or, with the previous sanction of the Chief Judicial Magistrate, any other judicial magistrate, may, for reasons to be recorded by him, stop the proceedings at any stage without pronouncing any judgment, and where such stoppage of proceedings is made after the evidence of the principal witnesses has been recorded, pronounce a judgment of acquittal, and in any other case, release the accused, and such release shall have the effect of discharge. 282. Power of court to convert summons cases into warrant cases. When in the course of the trial of a summons case relating to an offense punishable with imprisonment for a term exceeding 6 months, it appears to the magistrate that in the interests of justice, the offense should be tried in accordance with the procedure for the trial of warrant cases. Such magistrate may proceed to rehear the case in the manner provided by this SANHITA for the trial of warrant cases, and may recall any witness who may have been examined,